Welcome once again to Lehto's Law. Here's Steve Lehto.
Once in a while, a story crosses my desk with a headline so good that I know I can't skip it. Tim passed this along to me. Minneapolis to pay $785,000 in tennis shoe discrimination case. And it's not what you might think. The Star Tribune reported the case. Liz Navratil wrote it. Former Minneapolis firefighter Keith Daniel spent 5 years fighting City Hall over a pair of tennis shoes. And on Friday, his legal battle ended with the city agreeing to pay him and his attorneys $785,000 in what is actually a disability discrimination case, but it hinges on tennis shoes. Daniel is 59 years old, said, "For me, it was hard to believe that we went all through this for a pair of tennis shoes. I'm just glad it's over with, and I hope the verdict that I received sends a message to the city so someone else doesn't have to go through this." You might ask, what's this? Daniel is a member, or was a member of the Minneapolis Fire Department in 2001, and he had surgery to repair a torn ligament in his ankle. In 2011, he twisted the ankle when he was searching a house after a tornado struck North Minneapolis. His ankle problems got worse. According to a suit, Daniel aggravated his injury on the job in 2014, and after that, a doctor gave him a prescription to wear tennis shoes at the fire station to provide greater support and comfort for his ankle. So a doctor said, "I think you should be wearing tennis shoes to support your ankle." City firefighters, however, are required to wear black leather work boots as part of their uniform, according to documents filed in the lawsuit by the city. According to the suit, the department denied Daniel's footwear request, and then he re-injured his ankle when he was working at the station house in 2015. The department eventually agreed to allow him to wear the tennis shoes, but then reversed its decision. And then, after that, while wearing the work boots, he suffered another setback in connection with his ankle injury during work hours. He retired from the department because of his injuries and filed suit against the city. The case went to the state's court system, including the Minnesota Supreme Court, before it went to trial in Hennepin County in October. A jury ruled that the city was liable for discrimination and for failing to accommodate Daniel under the Minnesota Human Rights Act. Legal wrangling continued over the amount that the city would have to pay in damages. Case has been in appellate purgatory for a good 2.5 years while he went up and down the system, said Joshua Williams, who's the attorney for Daniel. That fighting ended Friday when, without comment, the city council approved the settlement for Daniel and his attorneys. Mayor Jacob Fry says he'll approve the settlement within days, according to a spokesperson. Daniel said he knows other firefighters who've had similar problems and hopes the city will make changes to prevent future cases like this. I guess I'd like to see them not use a person's disability to help cut the costs of their payroll. In a statement, interim city attorney Eric Nilsson said the city was constantly evaluating its policies and practices to ensure compliance with the law. Daniel said the past 5 years have been emotional, especially as his family dealt with his stress-related mood swings. He plans to use his settlement money on his wife and son. If I was 21, I'd buy a new car, but I'm 59. I've lived my life. It's for my family. He's been spending his retirement focused on them while his health rebounds. He's coaching his son's basketball team. He plans to shovel the snow that falls this weekend. I'm fine health-wise. I can do everything I did prior to the injury with the proper footwear. And so that's the thing. We often hear about these situations where someone comes into work and says, "Hey, look, I've got a problem. I've got some kind of physical disability, and I need accommodations for it." And generally speaking, you hear about places go, "Okay, no problem. Depends on what the accommodation is, as long as it's, makes sense." And so here we have a guy who has an ankle injury. And now you can understand that the fire department, generally speaking, says that a fireman's got to wear certain kinds of equipment, everything. I mean, they probably have regulations from head to toe, every single thing, a helmet, certain kind of jacket, certain kind of gloves, certain kind of upper coverings, certain kind of pants, all kinds of stuff. And so it makes sense that they would say part of that uniform is, in fact, the boots. Now, the question is, can the man do his job with the tennis shoes the same way he does them with the boots? And I'm not going to get into that because there's going to be a whole bunch of different things that they have to look at. And there's also going to be the question about the federal law versus the state law. And this apparently was ruled on under the state law. And I'm not familiar with Minnesota's laws on this. But generally speaking, if they're going to say, hey, there's really no reason that he couldn't do his job while wearing these kinds of tennis shoes versus these kinds of work boots, then it would make sense to make that kind of an accommodation. But if they say we cannot let you get the accommodation for some reason, and then he gets re-injured, then there's a problem, obviously. So it appears that a jury bought that argument, and it's gone back and forth up and down the appellate purgatory, which is a good way of putting it. But it appears they've reached, I guess, it looks like a settlement of $785,000. And that would be, in essence, for the injuries that he suffered afterwards, because they would not let him do what his doctor had suggested with respect to what kind of footwear he'd wear on the job as a fireman. So I've never been a fireman. I've known a few tangentially. I've never known any firemen really, really well. I've never had any in the family, for instance. So I'm not exactly sure how vital the footwear is, but I do understand that firemen are working oftentimes in what we consider to be a hostile environment. Not a hostile work environment, but a hostile to human environment, meaning that there's fire, smoke, things burning, going into a crumbling building, and things of that nature. So I understand that there are going to be standards they have for what they wear. But apparently, a jury thought that they would not accommodate him, and that was inappropriate. And then it went back up and forth on appeal a whole bunch of times. And, we've talked about this before. I did the story recently about the lawsuit that took 24 years to resolve. There have been cases that have taken maybe not 24 years, but decades, it seems. And it's often because you get a case that drags through the court system, and they get a trial. They get a verdict, and the verdict gets appealed. And appeals can take years and years and years and years. And heaven forbid that the appellate court says, something, we agree with somebody that something needs to be done differently. And they send it back for a new trial. And that happens. And when you go back for a new trial, you are literally at square one, starting over again. And that means that everything you just did could get done again. And in law school, I remember reading cases, several of them, where they go, here's the procedural history of the case we have to explain to you just so you understand. This case has already been back and forth, the Court of Appeal, several times. And now we're here on this issue. And this issue is a new issue that arose in the third trial. But the third trial came about because the second trial had a mistake in it. And the second trial is because the first trial had a mistake in it. And there are jokes. And there's actually, in some cultures, curses, instead of may your life be filled with joy and happiness, but may your life be filled with much litigation. So, you understand that somebody who's getting a resolution today may have been getting the resolution for something that happened years and years and years earlier. So that appellate purgatory is real, and it's ugly. But the tennis shoe case for $785,000 is settled, and that's good. Tim, thanks for passing on. Questions, comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. It's like nothing you've ever gone after before.